digital assets, blockchain, and relativity of title. So the speaker is Duncan Sheehan. Duncan is a professor at the University of Leeds. Before that, he was at the University of East Anglia, and he works in specialises in all areas of commercial law and private law. He's written a great deal on personal property, as you probably could see from his one intervention so far, and he has done a lot of work on digital assets in the last few years and been involved in the Law Commission projects in various ways. This, I hope I'm right in saying, Duncan, that this paper is to some extent taking issue with what the Law Commission says. And anyway, we thought we would allow the Law Commissioner the right of reply. So our commentator is Sarah Green. Sarah has been Law Commissioner for Commercial and Common Law since the 1st of January 2020. Well, she can tell you when she's leaving, which I know she is leaving fairly soon. But she's done this most extraordinary amount of work on all kinds of things, but particularly in the digital asset space. So the Law Commission has produced a huge amount of work on the report on digital assets. We have the Electronic Trade Documents Act, which is in relation to electronic, well, trade documents, things with kind of stuff. A bit too technical about these things. I was going to say it adds validity, but it doesn't quite, so we'll leave it at that. Anyway, that's been a huge area, particularly on the girls' lane side. And then she's now still heading up, obviously, the project on digital assets and private international law. So, Duncan, do you want to come and speak from here? And then everyone here.
Right. Those of you behind me will forgive me if I face the microphone because they can hear me. I'm sure you will be able to. Right. So, Louise was, shall I say, quite insistent that I talk about this. I opened up various things, but she's quite insistent that I talk about this. And as she rightly said, I am taking issue with the Law Commission and something fundamental that I think they get wrong in their report, and I think exactly a year ago today. And so then she's obviously about Sarah to reply, so I'm not entirely sure who's supposed to be doing the hatchet job on whom here, but we can make our own mind up. Okay, so there's an awful lot in the digital assets report. Obviously, it's a big fat thing. But there's one thing in particular. So, for the Law Commission, I'm really going to be talking about endogenous crypto assets like Bitcoin or Ether here. They are an example of a third thing, so not a chosen action and not a chosen possession. And I have issues with that as well, but we'll leave them to one side for a minute. And they are subject to, I think this is fair to say, control-based relative title to crypto assets. Okay? And so the paper that's published, if anybody wants to read it in the January issue of the General Business Law, basically makes three arguments as to why I think this is completely and utterly wrong. Okay? So the first reason is we are simply reinventing the wheel. It's just possession in a different guise. It is, as somebody from the City of London Law Society Financial Law Committee put it, I like this phrase, a possessory wolf in controlled clothing. The second reason is completely unnecessary because there's nothing that I think they want to do with a relative legal title that I can't do just as well with an equitable interest or a trust. And I think the way they put it together is conceptually and practically flawed. So there's not much coming back from there, at least in my view, but we'll see what Sarah says in about 20 minutes' time. So, take these in turn. Why are we reinventing the wheel? Well, basically, we're reinventing possessory title, which, as it happens, the Law Commission reject. Okay? So, let's just start with possession. There is an argument, and it will become clear that I disagree with this, that control of a Bitcoin is basically possession. Therefore, we should say I possess a Bitcoin. Okay, so the previous year's JBL has an argument by Shelby Lai, who basically argues that we can translate the definition of description, if you like, of possession into crypto assets. So we need a degree of sufficient factual control to possess a thing, right? So if I have a shipwreck, there's a shipwreck in the sea, and I've got divers salvaging it. Do I possess the shipwreck? This is Jubantia. I possess it if I have sufficient factual control of it. Do I therefore have sufficient factual control over Bitcoin by means of having the private key? Yes. Do I intend to possess it? Well, yes. And so everything that applies to watches, glasses, shipwrecks can also be applied equally well to Bitcoin. Now, that of course carries a lot of baggage with it, because presumably if I possess a Bitcoin, I can bail it, pledge it, and do all sorts of other things with it that you can do with shoes as in possession. And we get that relativity of title. Now, there are problems with this. The policy rationales for possessory title simply do not apply to intangible assets. Okay, so there is no register of title to glasses. Right? There's no register that tells you these glasses are mine, or those glasses are Simon's, or those glasses are fictitious. There's no register. Okay, there's no register that says this watch is mine. And it would obviously be bonkers if we tried to set one up. The reason why we all think that this watch is mine is because it's here, it used to be on my wrist, and now I'm holding it up. Okay, that's a signal to the world that I intend to control and take a stake in that asset, which we can assume to be ownership of these bills, unless I'm claiming otherwise. Now, a distributed ledger is, in my view, exactly what it sounds like. A ledger that happens to be distributed. Right? So the Bitcoin ledger, if you like, is a record of transactions that takes place with Bitcoin. It's a record of those transactions, and therefore it's a record of which Bitcoin or which addresses at any given moment in time and how they got there. So we don't need the public signal of, hello, this is my watch, I'm waving it in the air, because we have a record. It's not a perfect record, and I'll concede it's not a perfect record, but then I could have stolen this watch. You don't know that. I didn't, obviously, but I could have done. But it still counts as that record, so we don't need control or possession for that purpose. Now, is it possible I could lose my ring? This is part of British Airways board in an airport lounge. Okay, you could find it lying around the airport lounge floor, and then obviously you want to find out whose ring it is. You go hunting around, asking people, but in fact I've already caught the plane. Blah 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 blah. After a while, after the limitation period's up, it becomes your ring. Okay, you have to wait quite a long time, admittedly, but it does become your ring. It's to sort of defend your possession or lose it rule, adverse possession. But of course, there's no finding a Bitcoin lying around an airport lounge. You can't squat on my ether in the way that you can squat in my house. It just doesn't apply. That sort of adverse possession rationale simply doesn't apply. Nor does another historically popular explanation for possessory title, which is that it's a disincentive for you to punch me on the nose and take the watch. Now, obviously, there are criminal sanctions, but historically, that was one of the reasons, because I could always give it back, because I could always claim I have a better right to possess than use it by virtue of having been in prior possession. But you can't violently dispossess me of a Bitcoin. You can violently dispossess me of a bit of paper if I put the QR code that is my private key on it, but I'm protecting that because it's a bit of paper, not because it's got anything much to do with my Bitcoin. So possession doesn't work. So how does control reinvent this particular wheel? Well, at various points the Royal Commission in the report talk about superior and inferior title to digital assets. I think this is more explicit in the report than it was in the consultation paper, but let's say, for example, that I mistakenly transfer my Bitcoin to Louise. My mistake is so fundamental that I retain title to the Bitcoin, but it's obviously now Louise's address. So, but protecting her control, her actual control of the Bitcoin by way of some form of crypto conversion, and presumably protecting, though it doesn't say so explicitly in the report, my superior title by way of some sort of quasi-crypto reversionary injury tort. We can also presumably say that Louise is in actual control of the Bitcoin and I am in what? Constructive control of it? And this is exactly what we would say is actual possession and constructive possession of tangibles. It's basically exactly the same thing. We're even, and I've hinted at this already, defining it in much the same way. So you can illustrate this very easily because one of the criteria for an electronic trade document, like an electronic bill of lading, to be possessable is that it be amenable to exclusive control. And of course, there was also the question of intention. Right? Let's say, I'm sure she's not going to do this, but Louise has some cocaine in my bag, and I just stopped and searched on my way back to the train station on the high street. Oops, there's some cocaine, sir. You're under arrest for possession. Not feeling good. I don't know it's there. It's not the sort of thing I intend to possess, or know I possess, and I do not therefore possess it. Same way. If Louise airdrops some random tokens into my public address and they're not the sort of tokens that I intend to possess, come what may, and I don't know about them, then apparently I do not have a legal title to those assets. I need to intend to control and control, but that's just the same thing as possession. It is literally just the same thing as possession. Okay. B, second reason, is unnecessary. There is, I think, nothing that the Law Commission want to do with relative legal titles that I can't do with the trust. So they say it's really important that, in fact, it's bonkers that courts say a crypto intermediary, let's say Coinbase, not to be able to sue a hacker who hacks into the system and steals a load of Bitcoin. Well, yes, that's true, it would be. But that doesn't mean that I need to have some form of relative legal title. You can get exactly the same result, which is that Coinbase can sue by giving them legal title, just ownership of the Bitcoin, and I can still maintain insolvency protection in their insolvency if we then have a trust. So we don't need it. Right? We know that we can have trusts over these things because that's B2C to coin, let's go in Cryptopia, and there wasn't a trust with a Gatecoin in Hong Kong. We know that we can do this. Right? So it's unnecessary, and it's just possession with a different name. And the way in which they describe it, I think, is simply conceptually and practically full. So sticking with my custodial intermediary theme, if, let's say, Sarah has her custodian intermediary, and I give her my Bitcoin to hold on custody for me, then I am bailing that to her, because the money still retains it's my Bitcoin, and I bail it to her, she gets relatively lesser title based upon her actual control. And then Louise comes and also gives her Bitcoin to Sarah's custodian. So Louise is also bailing the Bitcoin to Sarah. Now we have two Bitcoin in the same address, or two Ether if you prefer. Doesn't matter. Because they are fungible. Doesn't matter which Bitcoin, which Ether you get back. So how does this work? Well, the analogy here, I think, is a case of Ray Stapleton Fletcher. Now, Ray Stapleton Fletcher, what you have are cases of wine in the warehouse, and they're selling to buyers, and the buyers hold the wine in common as legal tenants in common prior to the seller appropriating particular wine to particular customers. At which point, property in the wine passes. Or 100% property in one case passes, as opposed to them having maybe 10% stake in 10 cases. That tenancy in common, and this is explicit in Stapleton Fletcher, is created by means of the agreement. And yes, if I've understood the Law Commission correctly, title can only pass if there's a change in control. Now, I think this is important, right? And I think it's important that this is right, because otherwise, we could agree that I sell my Bitcoin to Louise and the property passes on the 1st of July. Right? And if we treat it the same way we do goods under the Sale of Goods Act, property passes to Louise on the 1st of July. Whether she has it as her address or not. But I've still got it at my address on the 1st of July. And then I think, aha, I've still got it. I'm going to sell it and transfer it on chain to Simon. And then Simon's got it at his address. Right? If we allow property to pass purely by intention, that's to me just an open invitation to fraud. So it's right, I think, that we should have to have some form of change of control to pass legal title. But going back to the custodian, the only change in control here is I've transferred control to Sarah. Louise has transferred control to Sarah. I haven't transferred control to Louise, and Louise hasn't transferred control to me. Right? So how is it, therefore, that instead of my owning Bitcoin 100%, I now have 50% of Louise's Bitcoin 2, and that she has 50% of my Bitcoin 1, as well as 50% of Bitcoin 2. Now, I suppose you could say, but by transferring control to Sarah, I'm transferring control to the other tenants in common, but that just seems to me to be making it up as you go along, okay? In other words, what I'm basically accusing the Law Commission of is having to rely upon the very analysis that they reject. It doesn't seem to me to work. In fact, it actually gets worse. So stick with this. Louise and I have bailed our Bitcoin to Sarah's crypto custodian. Let's just say that we're buying into this view that we retain superior legal title to that, and that Sarah rather has inferior legal title to it. Now, Javier and Simon also transfer their Bitcoin to Sarah. But this time, Sarah is going to hold on trust for Javier and for Simon. Okay, so far so good. Now what happens is that Sarah puts Louise's Bitcoin and my Bitcoin, that she's holding on a different basis, into the same omnibus account that she's holding the trust assets on. Okay, so now we've got 4 Bitcoin in this omnibus account. 2 of it she's holding on trust, and 2 of it she's holding for the bailment relations. Now, if we are serious about inferior and superior legal titles, and we are serious that this is the same sort of thing as possessory title, then the rights and the interest are identical. Okay? If I have an inferior legal interest or superior legal interest, the rights are the same. The interest is the same. All is different is the relative enforceability vis-a-vis each other of those rights. Okay? So, does the inferior legal title that she has to Louise and my Bitcoin get gobbled up by the superior legal title that she has over the assets that she's held in trust in the same omnibus account. In which case, Louise and I lose everything. That can't be the right result. Now you might say, hang on, no. There's two funds. It's fine, don't worry, there's two funds. But this doesn't work either. It's easy, I think, to demonstrate how. So Sarah's crypto custodian does something that never happens. They raid this omnibus account as a sort of a piggy bank for other purposes, and then goes bust. And this sort of thing never happens. Never happens. So now we have a deficiency. So let's say Sarah's crypto custodian takes 2 Bitcoin out. Has she taken Louise's Bitcoin from my Bitcoin, or has she taken Simon's Bitcoin and Fabio's Bitcoin? So now we have a priority dispute. And if we treat them as 2 different funds, well, so that I'm retaining superior legal title, then presumably legal title takes priority over equitable title. I'm sorry, Simon, sorry, Fabio, you've just lost everything. Or maybe it doesn't. Okay? Maybe because superior legal title eats up inferior legal title, I don't have anything, and the assumption is therefore that Simon and Fabio win. Now, supposedly, I'm not sure what the answer is here. Okay? But what I am sure of is it proves that there is a priority dispute, and therefore we cannot say that there are 2 funds at the same address at the same time. There is one. And we just have to apply some form of priority rules to decide who wins. Because I'm assuming here that we can't now trace the missing Bitcoin. Okay? It's gone through a mixer, it's ended up as an address that we don't know about, owned by somebody that we don't know about, in some jurisdiction that we don't know about. Okay, to go back to the 5 international law. Now, to me, this is just an open invitation to fraud. It's an analytical mess, and it is entirely down to the fact that the Law Commission have expressed a desire for a palette or a smorgasbord of different options from which people can choose, which are simply, in my view, logically incompatible. Practical problems. Now, Sarah is now a crypto lender like Bitcoin Suisse or UHODL. I want to borrow, let's say I want to borrow a certain amount of, I don't know, USDC. Okay? And Sarah says, well, okay, yes, you can, but you have to deposit a certain amount of Bitcoin worth, let's say, 150% of the borrowed amount with me in my hyper secure vault. Now, if that change of control is bringing with it a legal relative title to the Bitcoin that I've deposited in her hyper secure vault, then that's a pledge. If it's a pledge, then she has a duty of care to me. So if it is hacked, because it's not that hyper secure after all, and hacks never happen, do they? Then she is potentially liable to me. But Sarah is, of course, a clever commercial lawyer. She knows this, and therefore she does not want to take a pledge because she does not want that duty of care. She has decided that what she wants is an equitable fixed charge over the Bitcoin. And a fixed charge does not carry that duty of care. Now, the thing here, of course, is that Sarah also knows, because she's a clever commercial lawyer, that if I'm able to withdraw the Bitcoin at will, then it's not a fixed charge. It's going to be a floating charge. So what she needs to be able to say is, I can't withdraw the Bitcoin at will. And obviously the best way of doing that is to be able to say, you, Duncan, need to come to me and ask nicely if you want to take the Bitcoin away. And she can enforce that by what? By taking control. Now, that situation seems to me to present the problem that Sarah, has deliberately tried to avoid having the duty of care, but I think gets tripped up. That the law will tell her she's got that pledge and that duty of care, whether she liked it or not, pretty much, because of the change in control. And the fact she took it intending to take control of the asset. It's just, it trips her up. It also raises the difference between an equitable fixed charge. Frankly, how else do you fix the charge other than by taking control and the pledge? Right? Now you might say, okay, well, maybe the only difference here is that there's an intention to pass a legal title to the pledgee, but there's no intention to pass title to a chargee. Yeah, but of course the Royal Commission have said that intention is difficult to find, and of course at the same time title gets passed, or arrested title gets passed involuntarily in that mistaken payments context that I mentioned earlier. So I think the equitable fixed chargee gets legal title whether she wants it or not. So in other words, there are, as I say, basically three reasons why this doesn't work. We've reinvented the possessory wheel when the policy rationales for it don't exist. It's unnecessary, it's conceptually and practically flawed. And as I sort of suggested earlier when I was asking Matthias a question about ownership, it seems to me that like every other intangible, and I really do mean every other intangible asset that exists in English law, all I have, if I own a Bitcoin, is the rights that that carries with it. So I have a right that the system work in such a way that I have the benefit of that Bitcoin. And I either have that right or I do not have that right. It is unitary. That's how I own Bitcoin. I do not own relative title to the Bitcoin. It's unitary title. I just think the Royal Commission have this one wrong. And now Sarah can tell you why she was right.